Hi, good afternoon and welcome. My name is Marissa Bluestein. I'm an assistant director at the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey Law School. Welcome to our monthly training program for Conviction Integrity Unit staff and Innocence Organization staff and others who are engaged in post-conviction litigation and investigations. This series is made possible by a cooperative agreement with the Bureau of Justice Assistance that is presented to the University of Pennsylvania Carey Law School so that we can do these kinds of trainings and things. So we at the Quattrone Center provide support for any conviction integrity unit in the country, as well as innocence organizations and other groups that have grants under the Upholding the Rule of Law or post-conviction DNA evidence testing program. So if you are a grantee under that program not working with us, please feel free to reach out to us. We'd love to hear from you and work with you. And if you're from a CIU and you'd like to get some help, same thing. Please reach out. This is literally what we do. So that's all you're going to hear from me today. Thankfully for you, I'm going to hand it over to Taylor Migliori. She is our research coordinator at the project, and she has put together this panel along with Dana Bazelon, our former evaluation manager, current Quattrone Center fellow, to talk about how do we expanding this notion of justice out from exonerations. Are there other means that we can use to be able to assist people who have been wrongly convicted? So Taylor, all yours.
Great. Thank you so much, Marissa. Hi, everyone. Thank you so much for coming today to talk about expanding justice and the role that case corrections can play in conviction integrity work. Like Marissa said, we have three wonderful speakers today. I'm also co-moderating with Dana Bazelon. But just to introduce our speakers, we have Brianna Ford. She's the chief of the Conviction and Sentence Integrity Unit at Prince George's County, Maryland, at the state's attorney's office. We also have Jimmy Moody with us, who's the legal director of the Mid-Atlantic Innocence Project, and then also Erica Suter, who's the new director of the Maryland Office of the Public Defender Innocence Project Clinic at the University of Maryland Carey Law School. So lots of experts from the DMV area today to talk about case corrections in their jurisdictions and the types of resentencing statutes that they use on the day-to-day. So hopefully this will give you guys some new avenues that you might be able to pursue in your own jurisdictions, kind of find things that are similar, or just kind of get those creative juices flowing for how you can get relief for some of your clients. Okay, so that being said, in case any of you are new to this type of statute, here we go. These are some of the statutes that we're going to be talking about today. So if we could actually go around maybe Brianna and Erica first, talk about some of the statutes in Maryland, and then Jimmy will pass it over to you and talk about similar things in DC. So just sort of what you usually classify as a case correction in your office, maybe the differences in terms of like compassionate relief, juvenile restoration acts, clemency, the differences in those terms, and how you interact with each of those statutes. So Brianna, I guess we can start with you because you're on the
Sure.
left side.
Sure. Yeah. So, thanks for having me. I'm really excited to be here. I'd like to think that the unit that I am the chief of actually was created for what we're here for today, which is to address both things. And so I'll start by answering your question about what we have in Maryland. So we do have currently only the Juvenile Restoration Act. Second Look Act will sort of expand the Juvenile Restoration Act. It also comes with some carve outs that I'm sure we will talk about as we delve deeper, but that will not be in effect until October 1st. But both of those statutes endeavor to take a look at people who were sentenced young. So right now, under the age of 18, and that is what juvenile restoration looks at. And then second look will include up to the age of 25, and whether or not those people should be considered for reduction of sentence. And the statute sort of lays out 10 enumerated factors that the court has to consider in order to reduce someone's sentence. And so those are two mechanisms that we will have come October 1st to take a look at people who are, for all intents and purposes, guilty. They committed the crime, but maybe are deserving of a reduction of sentence. And maybe Erica wants to add anything.
Sure. So in terms of these statutes in Maryland, the Juvenile Restoration Act and the Second Look Act weren't written to deal specifically with individuals who are innocent of the crime. They were dealt with really, they were created to deal with the problem of mass incarceration and sort of our evolving knowledge and understanding about children and their capacity for rehabilitation. Nonetheless, with the factors that are, and the Juvenile Restoration Act and Second Look Act parallel each other in terms of the factors that the court needs to consider. And remorse is not an enumerated factor specifically to try and encompass individuals who have maintained their innocence and but otherwise also have demonstrated a good institutional record and rehabilitation and a plan for reentry. And so we do have overlap with our, prior to this position, I was the director of the Innocence Project Clinic at the University of Baltimore. And so in that capacity, we had individuals who were eligible for relief but had maintained their innocence. And so this is something that sort of encompasses that portion of the population, but also reaches much, much broader to anyone who's served at least 20 years and then can persuade the court that it's in the interest of justice to release them and that they're not a danger to society.
Great, thank you both. Jimmy, if you could talk about DC a little bit.
Yeah, absolutely. First, let me introduce Maggie Abernathy. She is one of our fantastic staff attorneys. For those of you who are here early, you've heard that I am going to have to duck out a little bit early, and Maggie is going to graciously step in and take my place to continue talking about this. She has fantastic experience both in Maryland and DC working under these relief schemes and has worked personally with both Brianna and Erica on cases. So I think you're actually in better hands with Maggie than you are with me. But I will certainly kick things off by talking about our statutory framework in DC. We have a very similar situation. It's called IRA, which calls for the Incarceration Reduction Act. And it actually started off with a similar set of parameters as we did in Maryland, where you had to be under the age of 18 and I believe serve, it was either 20 or 25 years. And recently we had an amendment to that act passed called the Second Look Amendment Act, the SLAA, and that greatly expanded IRA. So now IRA goes up to 25 and they reduce the amount of time you had to spend in prison down to 15 years. So it has been quite successful for us where we have clients who we have investigated, determined that, we have a good faith basis to believe based on our field investigation that there was a wrongful conviction. And it allows us to litigate the IRA sentence reduction potentially much faster than we are able to litigate the Innocence Act, Protection Act. So we're often able to, sorry, one second. We're able to do IRA, in about a year, whereas it can take multiple years for us to litigate the Innocence Protection Act. One feature I will mention that has been, great for our clients is that built into IRA is a understanding that where you are maintaining innocence, you are allowed to do that throughout your IRA proceeding, which is a huge win, as I'm sure you'll hear throughout this presentation. For some of these sentence reduction acts, there's either an explicit or an implicit expectation on the part of the court that the client admit guilt and kind of go into a discussion about their remorse for the crime that they committed. Obviously, from the perspective of an innocence organization, that would disallow us for pursuing that remedy. And in DC, we've had great success with the judiciary understanding that where the client is simultaneously pursuing innocence, that is not something that they're going to do and honestly, cannot be held against them. So that is kind of where we are in DC.
Great. Well, thank you guys so much for giving that overview. Is there any, sorry, I just got a little bit of feedback there. Okay. Is there anything that you want to say about, the different types of case corrections, maybe differences between them, between the terms that you don't necessarily think is clear? So like, for example, client seeking clemency, how is that usually different than like a compassionate release claim or like a traditional IRA claim from a client? Like how do those sort of differ between what they're seeking and what they eventually have to file for?
Sure. If you guys don't mind hearing from me twice in a row. Okay.
Yeah, we can also
Sorry.
switch to Maryland too.
Yeah, if you guys, Meg, I'm actually going to turn this over to you. I've now been told I'm not supposed to be doing this at GW. So,
Okay, fair enough. So we can switch to Maryland, and then when Maggie joins in, we'll circle
all
back
right.
to
Thank you
DC.
so much, folks.
Thanks, Jimmy.
Yep. Bye.
Alrighty, so maybe not IRA specifically, but the JRA or the Second Look Act in Maryland, since IRA is DC specific.
Sure. And you're asking sort of as compared to sort of like governor's clemency or that kind of thing.
Yeah, other types of sort of traditional case correction or resentencing efforts.
Sure. So there is such a thing as an innocence pardon in Maryland, and one individual who was able to do that with the last governor was John Huffington. And in Mr. Huffington's case, he won his petition for writ of actual innocence, but that doesn't preclude someone being retried. And so as that case was queued up for a retrial, he ended up taking an Alford plea. And so though he was freed at that point, he got a time served sentence. Obviously he was dealing with all of the collateral consequences of having 2 first-degree murder convictions. And in that event, he was able to ultimately, through a very long process, get an innocence pardon from the governor. But those are sort of exceedingly rare. And usually I would say in Maryland, applying for clemency or applying for a pardon or applying specifically for an innocence pardon would probably not be something that you would seek until you have sort of exhausted all of your other remedies. So typically that's not what we're doing. We are more likely doing something such as a sentence modification through the Juvenile Restoration Act, through the Second Look Act in the future, or even through just the right to modify a sentence that the client may still have.
Brandon, did you have anything to add, or we can continue?
I think that's right. Everything that Erica said is right. I think traditional modifications of sentence can be expanded a bit, right? We have different avenues in Maryland. In Prince George's County specifically, we have a reentry court that a lot of jurisdictions don't have anything like it. And it specifically focuses on giving people sort of under similar criteria a second chance to re-enter society. I think what's interesting about what Jimmy said earlier as it relates to someone maintaining their innocence and or being remorseful or not, we don't necessarily have that same language or protection here in Maryland. There isn't anything that definitively says that someone needs to be remorseful or that they can't maintain their innocence. But, and I think Erica maybe can touch on this a little bit later, but we've had some cases go up on appeal on these sorts of issues, and it has been challenging. We have had Juvenile Restoration Act cases where defendants do maintain their innocence, and for the state, that can be really challenging, especially in a case where we're actively investigating innocence and this person is still entitled to their JRA hearing. What do we do? What position do we take? The courts often do not like when people maintain their innocence, and so we're not quite as lucky as those folks in DC right now.
Great, well, thank you. I'm actually going to turn it over to Dana, who's our co-moderator. Like Marissa said, she was previously our senior evaluation manager at the Quattrone Center. She's now a fellow with us. So Dana, if you have some questions about the next section and the legislation specifically.
Sure. So I have a couple questions. The first is just following up on what Brianna just said, kind of asking her a follow-up, which is just how do you sort of decide? I imagine there are cases that come in initially as innocence cases, and then you or your people kind of look and you say, maybe this really belongs in the JRA category. how do you make those assessments? I know you can't share everything with us, but and how do you sort of, does there need to be a back and forth where that is sort of sold to the client from Erica's perspective? Like, how do you work to manage a client's expectations who's coming to you and saying, I'm innocent, and instead you're offering him what could be a way out, right? But also may come with less than sort of the exoneration that he had hoped for.
So Brianna, there are a few different questions. Do you want me to go or do you want to go? You want me
I
to
think she wants it maybe from the client's perspective. So you take it first.
I mean, I want both, but yeah, I'm happy to start with Erica, please.
Yeah. So I guess one of the things it sort of depends. So one of the things to sort of remember is if somebody is released through the Juvenile Restoration Act, that doesn't, depending on sort of how they allocate what they say, it doesn't preclude them from later filing a petition for writ of actual innocence. You can still do that. You could also, in theory, file a post-conviction or a motion to reopen so long as, even if you're released, so long as you're on probation or parole. So those avenues remain open. Sort of uniformly, the clients who are maintaining their innocence, obviously prison is a dangerous place. It's an unpredictable place. So most of my clients are happy to litigate their innocence from outside if it's possible. I think it's a much harder decision when you're in retrial posture and the client has to, and say the state's making an offer. And so like that was sort of what happened to John Huffington. It's like, and it's happened to a lot of people, do they want to take, how risk averse are they? Do they want to take a plea or not? So of course, ultimately it's the client's decision. I think most clients, so long as they're not having to, if a client has maintained their innocence, so long as they don't have to, accept guilt at that process, then they're happy with that. That has played out in a few different ways, and that's one of the sort of frustrating things, as it's very much a function of what judge you get, what jurisdiction you're in. Some judges are okay with a client maintaining their innocence, and they're more just sort of looking at their institutional record, what sort of strides they've made in prison, the same as they would look at anyone else who's similarly situated. But we've had other cases where the court has considered that a factor that counts directly toward dangerousness, because there's 10 enumerated factors and then there's 11 whatever the court wants to consider. And so when the Juvenile Restoration Act we were in the process of passing it, the chair of the House Judiciary Committee specifically posed a question about why remorse wasn't a factor. And Preston Shipp, who sort of was working on the legislation nationally and coordinating with local stakeholders, directly addressed it, saying there is a specific intention in omitting that as a factor because we want to be able to include people who maintain their innocence. And so, of course, we point to that conversation and cite to it because all these proceedings are recorded to the court. And it doesn't land well with all of the judges who consider it, hurtful to victims and, or who believe once the jury verdict has been passed that, a person is guilty. So it's very delicate. But whether or not the client wants to pursue one or the other, fortunately, it's not typically that one precludes the other.
And Brianna, I'm interested to see when you get a case, presumably a case comes in, the initial request is for, the conviction to be set aside. And then maybe you say, actually, I think it belongs in this bucket. And how do you make those determinations? And then how do you navigate those conversations?
Yeah, so it's a case by case situation, but I've had it happen a couple of times, and I think if the evidence is there, then we all want the exoneration, right? We all want to go forward on that if it's there. The question really is if it's not quite there, if you don't have the smoking gun per se, then what do you do? Do you focus your efforts on a second look or a JRA or a mod of some sort? Or do you focus on trying to find enough for the writ? And I have a case with Maggie in this position. We've gone back and forth for years now, literally. Um, and it's really tricky. I find that victims, right, because the state has to contact victims and victims are often involved. And I find that victims would prefer that if there's an exoneration, if things rise to that level, they would prefer that route. They want the truth as well. They don't want this person just released just because they've done well in prison. They would prefer the exoneration, which was interesting to me coming from the innocence world where victims often are opposed to that as well. It's like, come here and you talk to them sort of more directly and you see that most of them really want the truth. They believe the truth is that that person is the perpetrator until proven otherwise. So, but I do think that the elected, which is the person that I report to in these cases, is always going to want the exoneration if the evidence is there. But if it's not, I think it's important to be able to try to utilize that other mechanism. And thankfully, with Second Look and JRA, if they fall within those parameters, they're entitled to a hearing. And so that is helpful because then you at least you get in front of a judge on this mod and they're required to go through the factors and evaluate whether that person is deserving of a sentence reduction.
Maggie, do you have anything you want to add?
No, I was just going to echo what Erica had mentioned. Thankfully, it's not a one or the other option. And having a sentence modification can be a great way for the client to come home a heck of a lot faster than if we have to litigate innocence, which is never a guarantee that you're going to win at the end. And then the appellate process, as we know, can take many, many years. And I think ultimately, when you're describing these situations to the client, it's making sure they understand the implications of what one type of motion can have on another type of motion. So as Erica mentioned, if the court is looking for remorse and the client expresses remorse, that can obviously have an implication on a potential innocence motion down the road. So just making sure they understand the interplay of these two motions and how that can impact later litigation is really the critical crossroads for a lot of these clients.
And I suppose in a certain way it is similar. Now I'm going back to my own time as a defense attorney, which was many years ago, but it is similar to what you do sometimes when people, at sentencing, when people are still maintaining their innocence and you kind of walk that line of having them, at least speak to the judge in some way, but also not do a traditional allocution. So I guess
Right.
It probably
very similar to
something like
parole
that.
proceedings as well, where they want to hear them expressing remorse at a parole proceeding, but you can't because you didn't commit the crime. And so it's a tightrope walk of just trying to figure out how you can give them what they need to feel assured that you are going to be okay when you come home, but also maintaining that innocence so that you don't forfeit that ability to argue that down the road.
So I guess my next question, I'm looking at these statutes and thinking about them, and I'm so jealous that DC and Maryland have kind of seized these tools and are thinking about this differently. I know Pennsylvania, the routes to relief are so narrow, and then even when you can kind of like work something out with the defendant and his attorney, like some kind of alternative disposition, you really have to have the judge's buy-in to make it work. I'm just curious if you have any advice for people in other states about how to kind of push this like style of legislation forward, because I'm confident that lots of other places could benefit from it.
So I think there's a couple of things that are sort of broadly appealing about the impact of this kind of legislation. So like on the one hand, if you care at all about mass incarceration, right, then that's an obvious sell to a certain portion of the population. And if you care about racial justice, when we looked at our population of people who were convicted when they were children in Maryland, about 80% of that population was Black. So that was a metric that mattered to people. But kind of expanding from there is for states a huge cost savings with being able to release these individuals, especially because these are individuals who have served at least 20 years and in many cases much longer, right? So as individuals age within the prison system and have all of the attendant sort of healthcare issues, there's the general cost of housing an individual in our prison system, and then there's sort of all of the issues that accompany taking care of the elderly in our prison system. So I think there's some common sense factors about cost savings for states. There's some common sense factors about what we know about recidivism and violence and how it declines with age. And then also the statistics as we're following this population, and we've had sort of an earlier data set in Maryland because we've had this group that we call the Ungers, where there was a decision in Maryland having to do with a jury instruction that was given in the 80s, where all of these guys were entitled to new trials, but this decision isn't made until 2012. We've got a large group of very long-serving individuals, and their recidivism rate was so low, and our JRA recidivism rate is it's like something like less than 1% or something sort of across the state. And Brianna's got some great factors in her jurisdiction in particular, but they are generally speaking, an incredibly safe portion of the population to release. And so in terms of public safety, having people understand that and just that, and educating people about that, I think is also really helpful as we talk about the impact of this legislation and what it can do around the country.
Brianna or Maggie, is there anything you wanted to add to that?
When you first asked the question, what came to mind for me was sort of along the same lines of what Erica said, sort of educating people about what has happened already. And what comes to my mind is the people in Maryland specifically who have been exonerated, who maintain their innocence, and who were children when they were convicted, right? And so, like, I think legislators need to hear about those people so that they know that this is a real thing. People should still get that opportunity to be released from prison despite the fact that they maintain their innocence. That's really all I had to add.
Yeah, I was just going to add that it's always the hardest to be the pioneer jurisdiction moving forward. So thankfully, other jurisdictions have started going along this path and it's been working out really well. So that having these examples should hopefully give Pennsylvania some inspiration and other jurisdictions to enact similar legislation. I mean, my personal hope is that Maryland will eventually follow suit with DC and expand the age range, as well as other things. You know, they'll see how DC has done things, how well it's gone, and feel comfortable expanding it similarly.
From your mouth to God's ears, Maggie. I think it was one of the hardest things about post-conviction work here in Pennsylvania is just that the avenues are so narrow, and so trying to figure out how to fit certain claims into the available remedies. Anyway, the more remedies that you have available, it seems to me, the better you can be about sort of finding remedies for the people who warrant them. So as you kind of look forward to the law changing again, and kind of what do you see going forward as the challenges of trying to balance client needs and from the district attorney's perspective, public safety with kind of using these laws to the full extent that you can? And I guess, Brianna, why don't we start with you?
So I'm sorry. So you're asking what are the public safety challenges in using case corrections?
Yeah. So what have been the primary challenges that you all have faced on the prosecutorial side of making these laws work and kind of maintaining public support for what you're doing?
Sure. So I think it goes back primarily to what I was saying earlier about victims. You know, I think when we talk about them being okay with the person that killed their loved one coming home early, not serving their life sentence, it's a harder sell And so whereas I would love to be able to exonerate someone, sometimes we can't. And so now we're back in this position of trying to work through what we have. And it's even doubly hard because it's like, okay, we're going to let this person out. They maintain their innocence. We maybe agree with that, but don't have enough. And now, where is the real perpetrator? Are they out on the street? Are they committing new crimes? And so that is a real challenge when I'm evaluating these cases. If I'm going to bring victims in because they're entitled to be at every proceeding, they want answers, and understandably so. So that is a challenge. But again, I think from the state's perspective, right, we have to show up and we have to answer for these cases, and we have to go through the same factors. So when I'm analyzing a case and I'm looking at all of these factors that have to be considered by the judge, if they all are in the defendant's favor, then they're all in the defendant's favor. And the whether they maintain their innocence is not one of those enumerated factors. So I really try to see them separately. And like Erica said earlier, you know, not all the judges like that, that we see them separately, but I think we just have to. And the hope is that other states' attorneys and ASAs can get on board with doing that, with evaluating them differently.
Erica or Maggie, do you want to chime in, or do you also have any thoughts about your different experiences with different prosecutors' offices across the state, and whether are you navigating entirely different landscapes depending upon the office that you're dealing with? Is there some kind of does the law provide consistency, or is it really, does a lot of it come down to the individual prosecutor anyway?
Well, for us in Maryland, I think, so there are certain things that are consistent, as Brianna was saying, like we are entitled to a hearing, which in and of itself is, a big change and a fortunate thing for our clients. But there is a huge variation depending on, look, not every county in Maryland has a conviction integrity unit or a sentence review unit. And the philosophies vary from place to place. So there is quite a bit of difference depending on where you are. And then also, obviously, the cases themselves are very different. And so the facts will also influence the outcome. I think one story that I'm thinking about, though, kind of going back to the initial question, and it wasn't my client, but there was a case in Baltimore where someone had maintained their innocence, and there was an opportunity for them to go home through basically like a case correction, and he declined because he didn't want to do that. He wanted to prove that he was innocent, and ultimately, before that case was resolved, he died in prison. And those sorts of examples. We have another client who was exonerated, not through a case correction, but through a petition for writ of actual innocence a couple of months ago. And when I got to court and stepped into the back to see him, he showed me that he had stitches in his face and stitches in his chest because he had been attacked just a few days before we had gotten to court. And God forbid he had to get, sent to the hospital by ambulance. And those things, as the attorney, are always on the front of my mind. There is such an urgency, despite the fact that I think, as Brianna very rightly puts it, of course, we all ultimately want to see if we believe that somebody is innocent and the evidence is there to get us to that point, that is the preferred route. But as Maggie was saying, it takes years sometimes, and there's a lot of challenges. And the client, even if you win, if the state appeals, maybe you're still incarcerated, subject to all of the sort of dangers and unpredictability. Most of our clients now are telling us with staffing shortages, they're, in their cells 23 out of 24 hours a day. So there's all of this sort of additional information that has nothing to do with somebody's guilt or innocence that is always, I think, as attorneys and having seen some of these things go really badly, they're always in the back of our minds.
Yeah, absolutely. There's going to be variation amongst the prosecutors, amongst the judges. Nothing is ever set in stone, no matter how good your petition is. All you can really do is make it as strong as possible. You know, you want to have that great reentry plan to assure the court that they've got support, whether it's family, community, jobs, substance abuse support, anything to make sure that they succeed on the outside, because these people have been in prison for 20 plus years. It's a whole different world and it's a shock to the system, no matter how well prepared you think you might be. So all you can really do is make it as strong as you possibly can. And I know in DC, they've tried to somewhat make it a little bit more fair. In Maryland, I believe it goes to your the predecessor or the successor judge for your sentencing. In DC, they've randomized it so that when you apply for IRA, you get a random judge in the hopes that maybe that creates some equilibrium in case there's one judge that is a little bit harder than another judge. So there are some mechanisms to try and improve that in the future, but no matter what, you're going to have variation.
I wanted to piggyback on that. It reminded me one practice tip for defense attorneys, I think might be it. So oftentimes in a JRA or a second look to come, we utilize evaluators for risk assessments, right? And they come to court and they testify about that person's likelihood of recidivism and why. And that is a good resource for putting someone, an expert, on the stand and having them be able to testify about whether or not they are concerned about your client maintaining their innocence and why or why not, and explaining to the judge why that actually doesn't impact the risk. And I think that can be helpful.
Oh, that is super interesting. Thank you, Brianna. And an excellent practice tip. I wanted to go back to something that we sort of gestured at, but I'm interested kind of in how victims, in your experience, play into these cases, how impactful they are generally. Like, do you get the sense that they the concerns either about sort of really making victims terribly upset, or sort of that I'm just curious if whether victim involvement and like passionate victim involvement seems to influence like the end result in cases, or whether it's sort of it can make the process more difficult, but in the end it doesn't have a tremendous amount of impact in your experience. I mean, obviously it will vary case to case, but I'm just curious to have you guys opine a little bit on your impression of kind of working with victims through this process.
So from my perspective, the answer is yes to all of those things. It can make the process more difficult, it can prolong things, and it can have a very direct impact on the outcome. The helpful thing, I think, from the defense's perspective about the JRA and the second look in Maryland is that the decision from the court actually has to be in writing, and it cannot be given that same day as the hearing happens. So I think it's helpful that all the emotions of everything are not there when the decision is rendered, and but absolutely it can make or break a case from my perspective. Yeah.
The smart judges in Philadelphia used to hold a lot of things under advisement at the end of trial so they could come back a different day. So that is actually, it is actually just smart, I think, to let everyone settle down and take a beat before rendering a tricky decision. But Erica or Maggie, do you want to opine a little bit on your experience with this?
I was just going to add that in innocence cases in particular, victims, I think, can be very frustrated when your clients aren't expressing responsibility, because in their mind, they don't see development that is required for a sentence modification. So I do think that is a particularly unique challenge when we have our innocent clients seeking relief in this way. Ultimately, my hope is that one would always expect, in general, a victim's family to oppose or have some strong opposition to a sentence modification. So that's more of an expectation, and it becomes a little bit more surprising or powerful when a victim's family actually supports a modification or is okay with someone coming home and recognizing that they've developed and grown and have that chance to come home again and have that second chance. So for me, it's really exciting when a victim's family comes in and supports relief because I think it can be extremely powerful.
Yes, I imagine they can have a tremendous impact if they come in that posture.
It also is very helpful from my perspective as the state, right? I obviously answer to a boss, and they are more inclined to be supportive when victims are supportive. So yeah.
That all makes perfect sense. Do you guys have any thoughts? I mean, as other states kind of, at least hopefully, think about developing legislation like this, do you have thoughts about ways that the legislation you're dealing with could be improved, or kind of things we should watch out for as we think about pursuing these sorts of alternative routes in other states that you've learned from your experience?
A couple of things. Well, for me personally, and maybe we'll see this at some point with the legislation in Maryland, is I would love for there to be sort of an explicit factor that says that somebody maintaining their innocence cannot be held against them, because the catch-all factor allows the court in its discretion to make its own decision. And obviously different judges feel different ways. So I would love to see that. As Brianna was talking about the risk assessment, in our legislation, one of the factors is if a psychological assessment has been done, that the person may offer that. And so it's not a requirement, but obviously when a judge is making this sort of public safety decision, it can be very helpful. The reentry plan, we're fortunate in the Maryland Office of the Public Defender where we have somebody who helps, somebody whose job it is, they're the community reentry coordinator, who helps us sort of create these very robust home plans for people. That's not a factor, but I think, again, it is something that offers some reassurance to the court and to the state that this person is going to have reentry housing. There's going to be job support training. There's going to be, tech training. There's going to be support groups, all of these things, this sort of safety net that we as an agency are able to provide for our clients, I think is very important in ensuring that they're successful and that they don't sort of fall through the cracks. The other thing that I think can be troubling about the language of our legislation in particular is the court has to, after considering these factors, the court has to make two findings. They have to make a finding that it's in the interest of justice and that it's not the person is releasing them is not a danger to society. And so the danger to society thing, I feel like that's a fairly different, people will feel differently about that, but that's sort of a straightforward factor. But the interest of justice standard is very squishy. It's language that's in other legislation in Maryland. In our motion to reopen a post-conviction, the court has to decide that it's in the interest of justice to reopen. And I think that can sometimes, I don't know where to land with that, but I think that language can be tricky because it's fairly ambiguous.
I am going to turn it back over to Taylor to do the last part.
Beautiful.
Thank you, everyone.
Great. Thank you so much, Dana. Thank you, guys. That was really helpful. So we've sort of been alluding to the fact that you all have worked together on cases in the past between MAPE and, the Office of the Public Defender and the CIU. If you guys could talk a little bit, obviously no case details or, specifics, but in general, how that collaboration effort works, if it's different than, you taking on a sort of resentencing case in your office on your own, what those conversations and discussions look like. We can hear from each of you. So whoever wants to start.
I mean, I'll just say it's been incredibly helpful to have someone on the other side to work with and collaborate with. You know, you get to exchange ideas for what's needed and what they need in order to support release, which so it just really gives you a good idea of what is going to make your petition as strong as possible for your particular unique case. You don't always get that when you're working with offices that don't have a conviction integrity unit or a sentence review unit. It's more of a black box. So I've found it incredibly helpful. Obviously, just because you're partnering doesn't mean there's a guarantee that you're going to get relief and that your client will be resentenced. But it's a better place to start than not having that ability to collaborate.
Great. Erica or Brianna?
I'll piggyback on that for a second. I think the other benefit, obviously, to having a collaborative working environment on these cases is, for example, we've talked a lot today about like, you win your writ of actual innocence. If you're working collaboratively with the state's attorney, it's less likely that they are going to reprosecute. And so I think that that is a helpful piece. The I think that the collaborative nature is incredibly helpful from my perspective as the state because I'm not starting from scratch. We all know starting from scratch is 5 years from anything happening or more. And so I love to be contacted by the defense and they say, this is a case, this is what I have. Where do you think we can go with this? And I think, obviously as the state, I have access to our internal files. I have access to police files. I can look for things that might answer the question that the defense is looking for. And so I just think it expedites the process. We all ultimately want to get to the truth, right? So, and the flip side of that is the defense has, this is why I didn't talk first, like the defense has obligations to their client. And so it makes it sort of a little tricky sometimes if they have something, maybe they find something, or we go on a joint interview and we hear something and now, right, they can't necessarily move forward on the case. So, but all in all, I am a big fan of the collaboration. I think it leads us to the truth quicker.
Yeah, I agree with what Brianna's saying. I think one of the things that's a couple of things that are particularly helpful if you are able to collaborate with the state is one, sometimes the state can be clear about sort of what they're looking for. So different offices may have, somebody may put a particular elected may put a higher priority on education or may put a higher priority on particular kind of programming and being able to be clear on that and have that communicated can be helpful as you're advocating for your client. So I think that can be useful. Also, I think that, judges who are thinking about public safety and, when I talk with my students, we're always sort of encouraging them to put themselves in like the decision maker's shoes, like what's important to them, what do they need to know? You're not going to be an effective advocate if you're simply looking at things from your client's perspective, although that's one thing that you do. But as the judge is sort of making this calculation and has concerns every time that they release somebody, that they're taking a risk on someone, if the judge can see that the state and defense have come to some sort of agreement, I think that can help the judges with their decisions. But yeah, there's always, it's always tricky as well, being able to, keep your obligations and your duties clear in relation to your client while you are working with the state, because you do have very different jobs.
Right, absolutely. And that actually segues perfectly into the next question, which is, have you encountered any judicial pushback, I guess, when you're coming to court with, an agreed upon outcome for a client, or is it typically, that outlook of, oh, well, the defense and the state agree, that should be an indicator for this case. What have your experiences been? And again, no specifics, but just in general, how do you navigate those sorts of encounters with the judges?
Sure. Here, I'll start with this one. I think, again, putting yourself in the position of the judge, you know, a particular outcome is never a foregone conclusion.
Mhm.
So obviously part of your due diligence is knowing about your judge and how they view things. But I think in terms of from a defense attorney's position, you have to be as prepared and sort of have all of your bases covered as if this was a totally contested hearing. I think that's the mindset with which you go forth, regardless of the state's position. And in doing that, because I don't think any judge would ever want to appear as if they're just sort of rubber stamping an agreement between the state and the defense. And so I think in honoring your obligations to your client, and also sort of being mindful of the kind of decision that you're asking the judge to make, you need to sort of present your case as thoroughly as if it were going to be a fully contested hearing. And I've definitely had the experience where judges have been satisfied with an agreement, and I've also had the experience where judges push back. And not necessarily declining it, but that, you are going to have to persuade this court fully that, this particular client that this is the appropriate outcome.
Agreed. It's very judge specific what you sort of put together and present. I think the other thing that we find is that victims, again, play a large role in this. They have an opportunity to be heard when a sentence changes, especially if now we have new case law where if there's going to be a vacatur. And so you've got to consider that. And I will just say, because I wasn't sure necessarily whether you were asking about an agreement as it relates to an exoneration or to something like a JRA or second look, but I always go back to, I'm actually really happy that we have those enumerated factors set out in JRA, because again, I think you can rely, whether you're the defense or the state, quite frankly, you can rely on each of those enumerated factors and whether they weigh in the defendant's favor or not. And so I find it helpful when coming to a position about whether someone should have their sentence reduced. Similarly to if it's a writ, we've not done that yet, and I hope we do it soon, but if it's a writ, the law is clear and the evidence is hopefully clear, and right, you're putting your best foot forward, regardless. So
Great, thank you. Maggie, anything to add?
I think that just about covers it.
Perfect, great. Okay, and then the last thing that we'll talk about before we get to audience questions, because it's almost the end of the webinar already. But if you had either a piece of advice or just like a lesson learned, whether it's the collaborative process, whether it's, how to prep these cases for different judges, basically anything and everything under this case corrections umbrella that we've talked about today. Kind of the one thing that you've learned over the past couple of years to impart on the people watching.
I think I would just say flexibility is really important, sort of knowing all the different facets of your case, the judge that's going to preside over it, what you have, how they feel about innocence, and taking a look at all of the available avenues for relief. So long as, like we've talked about, if you're not precluded from pursuing innocence later, getting your client out is probably most important if you have it there available to you. So just sort of being flexible and working through what you have. And even from the state's perspective, I've got to consider, what sort of victim do I have? Have they expressed that they would rather see an exoneration if that's the case? Maggie and I have that in a case that we're working on. And so, yeah, that's my tip. Flexibility.
Perfect.
Yeah, mine is really just, you got to do the legwork. You got to talk to the family, you got to talk to the friends, you got to talk to prison officials who have interacted with your client. You have to get the records, maybe hire an expert to opine on either psychological things, recidivism, anything like that. You really just, you have to do the work to make it a compelling motion. Otherwise, your chances are just much lower.
I think that it's important to, it's a different hat, right? To be working in collaboration with somebody versus sort of, I think working in collaboration is not the opposite of like zealous advocacy, but it is important to, again, I think try to put yourself in the state's shoes, to always be above board to the extent that you can, while kind of, obviously honoring your obligations to your client. But I think if you've got a state who's willing to talk with you and work with you, then to be, to the extent that you can, as sort of flexible and helpful as possible, if this is someone who's actually maybe going to help your client ultimately, which can feel like a bit of a shift sometimes in our roles where we're just duking it out with the state, but trying to be mindful of that shift and being sort of as above board and as helpful as you can be, I think can really benefit your client.
Great. Well, thank you so much, ladies. Dana, if you had any follow-ups, I'm happy to turn it over to you for those. While you're doing that, I do have a couple of QR codes just for things that we've talked about today to make it easier for you to find them online. So if anybody wants to scan those are up for you. The Second Look Network that I mentioned in chat is up there as well. And then if you also have any follow-up questions for myself or any of the panelists, the QR code for the Quattrone Center's help email is also up here. So you are welcome to send anything our way. If you need help at an IO, a CIU, your organization, if you have any questions about today, we are here to help. But with that, I think we do have one question so far. So if you guys have questions, please feel free to send them in chat and we can pitch them to Erica, Brianna, and Maggie. But Marissa actually had a question, I guess for Erica, but maybe Brianna and Maggie as well if you have things to add. And this was back from a couple of minutes ago about how you deal with the ambiguities in the filings. So if you take a party position or you just sort of like pre-game it for the judge when you're prepping those cases.
I think to do it effectively, so the specific ambiguity that I was talking about, right, was like, what is the interest of justice? And to me, like, I've got personal views about what are the interests of justice that may not be shared by the judge that I'm appearing before, the state or whatever. So I think to be effective, you need to have as much information about your judge as possible, right? So judges sometimes have particularly strong feelings about a certain kind of crime. Maybe your judge does have strong feelings about the capacity for children to be rehabilitated. But I think to be able to advocate on that issue as to why it's in the interest of justice to be able to release that client, I think it is helpful to speak with as many people as possible to try to get information about that judge so that you're shaping it for what it is that they're looking for. And for me, because I practice all over the state, you really got to rely on your local practitioners to get some of that information.
Right. Brianna and Maggie, anything to add to that?
Nope.
Okay, great. If anybody else has questions, we're happy to take those. We'll give people a couple of minutes maybe to get their thoughts together and send them in. But I just lost my screen. But other than that, if you guys have any final thoughts to share, or we can just give folks a couple minutes of their day back this afternoon. Or again, with Dana and Marissa, if you guys have any follow-ups, happy to open it up to you guys.
So not particularly follow-ups, but I'm very grateful for this discussion. Thank you all for just how frank you are about the difficulties in this area. I just want to remind people that because we do this with BJA, we are required to collect information. So please fill out this very, very brief poll before you leave us. And while I have the floor, I will talk about what's coming up. So next month we are going to be, so I think as folks know, we've been working to try to find good, reliable programs for people to use using AI or others to help make your lives a little bit easier. Our data dude, Chris Elworth, is going to be presenting on a program called Everlaw next month, and also answering other questions that you have about use of AI in your case screenings or other means, like what kind of questions you have, what privacy questions you have, what programmatic questions you have. Chris will be able to answer those. On August 21st, Adina Thompson will be hosting the new DNA attorney group. If you're not part of that group and you think that you want to be, please contact us. We'll be happy to connect you with that. In October, so September is the Everlaw. In October will be a DNA and contamination considerations webinar with Adina, and I think our resident expert, Anjali Ranadi from Arizona. And then November and December, we're going to be covering a two-parter on ballistics, on how to evaluate ballistics information and potentially get new testing done for cases that you have. And then in January, we're back to DNA again. So we have a full lineup. But as always, if you have topics you would like us to cover or experts you'd like to hear from, please let us know. We're happy to put that together. So Taylor, I'll put it back to you.
Great. No, thank you so much. And again, thank you guys so much for speaking today. Dana, thank you for co-moderating with me. If you guys have any questions or you, like Marissa said, have ideas for future webinars, you can send those to our QC Help email address or to Marissa or I individually. So thank you again so much, Brianna, Erica, and Maggie also for stepping in today. We really appreciate it and hope that you guys have a good rest of your afternoons. We'll give you guys a couple of minutes back here, but thank you all so much. We really appreciate it.
Thanks for having us.
And thank you.